who's joining us for this webinar. We're really excited to have you here today to host this webinar, this very crucial webinar. It's one of the series, the IP webinars that we've been offering in support of with the African Center for Technology Studies and with JQuat. One of the things that we've been keen to do is actually bring practical experience and practical success stories on IP registration for innovators. And today we're really happy that one of our resource persons at ACTS actually happens to be a prolific innovator who has patented quite a number of innovations. So this webinar is brought to you through the collaboration of the Gender, Youth and Inclusive Development Program and the ACT AI Institute. I'll speak briefly about the gender program. Our vision is to empower women, youth, and vulnerable groups to harness science, technology, and innovation for economic, social, and environmental sustainability of Africa. And one of the projects in which we're doing this is through the Green and Digital Innovation Hub, a 6-member consortium hub that is supported by the EU and GIZ. And it was set up as out of an urgent need to support green digital transformation in the MSME sector in Kenya. And one of the things that MSMEs said that they would have wanted to be supported on was on IP registration, on patent registration, on trademarking, understanding more about how to protect their innovations, especially because green and digital innovations are in a very new, area, a very novel field. And so we've organized, within the collaboration of JQuat, we've organized a series of activities, webinars, and sessions to support innovators in IP. And so today we have a great speaker. Dr. Ojenge will introduce himself a bit later on. But for now, I just want to pass on to Clarisse, who is the key contact person on IP. She's a very young person, but also very knowledgeable on matters IP. And so we're very fortunate that she'll be speaking to us a bit about IP and the process that we've been able to support innovators so far. So over to you, Clarisse.
Thank you so much, Doc, for that wonderful introduction. My name is Clarisse Mideva. I'm an intellectual property research assistant at ACT. So I'm just going to take you through the ACT IP services and the TISC, the Technology and Innovation Support Center. So maybe I can just share my screen. I hope you can see my screen.
Yes, we can. You want to make it a bit bigger?
Yes, okay.
Yeah.
Yeah, there you go. There you
go. Okay. Okay. So at ACT, we have an intellectual property unit, and this is really important because when we are talking about research, there is so much creativity and so much outputs and innovative ideas that are poured out. So it's really important that we have an IP unit at ACT where people are able to protect their ideas and also ensure that people out there are actually not commercializing or taking advantage of their creativity or their hard work. So our vision at the ACT IP unit is to become a leading catalyst in transforming Africa into a continent that IP drives sustainable development and also fosters innovation, creativity, and knowledge sharing. And our mission is to foster innovation and creativity in Africa by ensuring that IP is promoted. And some of the goals and objectives of the ACT IP unit are to help in access to innovation and information services. And this will be done through the TISC. I'll explain later what the TISC is. And also we do a lot of training and capacity building on intellectual property rights, and this is one of them. We also facilitate commercialization and transfer of technology, We undertake research that promotes use of the IP system. When you visit our website, especially the Green and Digital Innovation Hub, you can find that we've published some articles on various aspects of intellectual property. So we also undertake research. So ACTS was recently established as a TISC, a Technology and Innovation Support Center. And what a TISC is, this is an initiative by the World Intellectual Property Organization, where it was designed to provide innovators and researchers, especially those who are from the developing countries, with access to technology, information services, and other IP-related services. So, and these technology innovation services that we're talking about is access to patent databases such as Google Patents, SpaceNet. There are lots of innovators who don't know how to maneuver, how to use this kind of information. So that's one of the services that are offered under TISC. And WIPO works with the governments in the member states to establish these TISCs. So WIPO worked with the Kenya Industrial Property Institute, and they were able to establish ACTS as a TISC. And some of the objectives of the ACTS TISC is to ensure that there is availability of science and technological information that will help innovators and researchers to improve the quality of their research and also quality of their innovations. They are able to see what other people out there are innovating on, and they can emulate and improve on those innovations to suit the African market. And also, another objective of the TISC is to help innovators to create, protect, own, and manage their IP rights. So when you're talking about the ACTS TISC, when I say that we'll be offering services, IP services through the ACTS TISC, here we'll also be, we are also assisting in filing and registering IP rights. So if you want to register your intellectual property right, you want to register your patent, your copyright, we help you do this. We also help you to access the patent information that I was talking about. We help you to access the publications. KIPI normally has publications monthly, and also the African Regional Intellectual Property Organization has journals. So we help you to access this kind of publications. We assist you in doing patent searching. We train on intellectual property and also searching of those databases. We do on-demand searches. So if you want to find out if your idea is novel, it's new, we help you do that. And we also provide information on how you can manage your intellectual property, how you can protect it, how you can commercialize it, and how you can enforce it. So these are just some of the services that we are offering at the ACTS IP unit. So now let's move to the heart of let's move to the heart of our session, which is Dr. Winston Ojenge's personal journey with the patenting process. And I'd like to welcome Dr. Ojenge so that he could just introduce himself.
Karibu sana, Doc.
Thank you, Clarisse. My name is Winston Ojenge. I'm a research fellow at the African Center for Technology Studies. I head the ACTS AI Institute, also lecture computer science at the Technical University of Kenya. Thank you.
Thank you so much, Doc. That was a nice introduction to yourself. So we'd just like you to briefly just tell us the key steps that you took when you were filing your patents in Kenya. What were the biggest challenges that you faced during that patent application process? Since we know you've filed around 5 patent applications in Kenya.
Thank you, Clarisse. The steps, I think, are pretty standard. The first would be to determine the patentability of your idea, and determining the patentability we usually would take three considerations. One, how novel is it? Novel? It has to be new idea, or there has to be a component of that idea which is new. Then industrial or business applicability. Is it applicable in any process within industry or business? Then the more difficult is the inventiveness of that idea. There has to be what they call an inventive step, meaning that what you claim, that component that you're claiming, must not be obvious to someone who is skilled in that domain. And I know that's usually where the difficulty is. Second, then you conduct a patent search. Once you've established number one, you conduct a patent search. You to ensure that there's no such idea or claim that is existing globally. And some of the searches you would be on WIPO, Google Patents, etc. And especially United States Patent and Trademark Office, because there's loads of thousands of patents that come out of that office every year. So you want to check that site as one of the ones you survey. You need then to choose the type of patent, but I guess, okay, I chose utility patents, which is most common. There are others, of course. Then next was prepare detailed patent application. So you have to have abstract. There has to be background and description. There has to be drawings, diagrams, and then the claim. Where exactly are you placing the claim? So then after that you will just go on and file the patent. Well, I was paired that part of the process because I did my patent application through the Technical University of Kenya, and the patent attorney, there's a patents office at the University of Kenya, and took over after I'd failed the application. He took over to push with Kenya Industrial Property Institute. And you would, of course, pay fees and wait for the examination period. So they would take your claim and start going through similar databases and their own resources globally to be able to identify whether you really are, what you're claiming as patentable is really patentable. You to go through that, then they would respond to. Usually, their response would either be that it's a straight yes, or they would be having issues with parts of your claim that they found in or they found in their databases or within their searches. And they will tell you that this part might have been already published. And you can't claim. A lot of times they would be back and forth. They would be making those claims, and then you have to remonstrate with them if you feel that they're wrong. A lot of times they would not be very precise because they would not be perfectly expert in that narrow area. The patents, the KP, relies on its set of experts who cannot be expert at every area.
Philip, kindly mute, please. Philip, please mute. All right, Dr. Ojenge, at what point did you know you had an idea that ready for patenting? I mean, today that how will I know that it's time for me to go and protect that idea of patent it?
That's a very good question, and I think that is a question that most people are wrestling with. It takes, in my case, I believe that it took experience to know that there is opportunity for protecting your idea in patent, and that you don't have to have developed the actual artifact, in order to patent, and the fact that that idea is patentable. So there were many ideas that have gone through my head over the decades, and as you can see, I'm not 20-year-old, and I'm perfectly sure that so many 20-year-olds or youthful people, and actually that is where most people conceive new ideas. People are most innovative at the youth. That's what I believe, because I feel most of these people who historically invented did their inventions at youthful years. Of course, we later got to know them at advanced ages, but and that's I think the burden we have. How are the youth who are most innovative able to diagnose if they have the right ideas? So it's difficult to tell exactly when that occurred, but I know that my first application was around 2016. But I'd mulled it over in my mind for years before I actually did it. Okay.
Thank you so much.
Oh, sorry, go ahead.
No, go ahead, please.
Okay. I think one of the things young people might also struggle with is the process of patenting. And you've said something very key and something that maybe young people don't have at their, at their disposal or within their resources, that you happen to file your patent at the Technical University of Kenya, and that there were lawyers who were able to support you through that process. Maybe you can take us a bit through that process of having a legal person, and how critical is that for the actual patenting process? And maybe if you can also talk a bit about the fees. Was the fees then subsidized by your university? And maybe by that, then does that mean that the patent is jointly held by you and the university? Sorry, I know these are many questions, but maybe you can talk about the legal aspect first.
Yes, I think quite a number of universities have a patents office. So there's a patents attorney who is, a lot of times they are attorneys at law. Before then they focus on the patenting process, and some are not attorneys at law initially. And so the Technical University of Kenya happened to have one, and he guided me by giving me templates coming from KIPI that suggest to you what you're supposed to put where. And as I would put and the content I'd share with him, then he would always focus, he would always emphasize on that inventive step. So I would draft initially and share with him, and they would tell, no, but that is not adequate. You need to put in more information. Of course, they still, one of the challenges is that the patents attorney is not technical, so would not assist you to harvest your idea correctly, technically. But they wouldn't know what else that you're supposed to put in. But they would read through, and from experience, they would know whether they are convinced or not. And then they would take over that process and file that at KIPI. The money I know isn't really much. It's probably about 14,000 or thereabout. Basically, there'll be a filing fee of about 3,000. There'll be a publication fee of about 3,000 after 18 months. There'll be an examination fee of 5,000. Then when they grant you the patent, you'd still pay another 3,000. That's about 14,000. Basically, I know there are other smaller fees. The trouble now is that most people would want to patent are youthful. Yeah, they're youthful, and 14,000 is still steep for them.
So it was Kenya shillings, 3,000 Kenya shillings.
Yeah, that is 14,000 in Kenya shilling. That would probably be about 120 USD. Yeah, thereabouts.
Okay. All right. So if you use the attorney support from TUC, does that mean that now your patent is jointly held, or does that mean it's still those are supporting support, a support that the university advanced to you at no cost? Does it mean that your patent is still yours?
The university would claim a share of 40%, of course, depending on every individual university or hub. I need to mention that I think there are hubs that do that too. They put up the money for you, and they would also support you in that process, but they would claim a certain percentage of the patent. So TUC claimed 40%. So it holds 40% of all the five patents. Of course, there's a sixth in examination now. But that should not be a worry, because remember that it holds 40% of the patent, not the commercial value of that patent. If you were to sell your patent today, you would probably sell it at how much? I don't know, maybe 10 million, 20 million Kenyan shilling. But whoever is buying the patent knows how to exploit it within an industrial business process and convert it into maybe millions of dollars, hundreds of millions of dollars. So what then for the university would own would be the IP itself, but not what later would be converted into. There's massive resources. So it still probably be worthwhile to give out a part of it, consider part of your IP and get it done.
Okay, Clarisse, go ahead.
Okay. You mentioned something about having the correct documentation, like having the abstract, the claims, the drawings. Did you draft the patent documentation yourself, or did you get help from the IP office? And what are your recommendations to any innovator that has a product or a process that they would like to patent?
Yes, the patent office gave me the template. There are forms that state exactly what content you're supposed to put up. For instance, initially you're supposed to do an abstract, and the patents office, our attorney, of course, would go through your abstract and tell you whether you need to add more. Is it convincing enough? You need to add more. They would not be able to support you really technically, because they are not technical people in terms of what you want to patent. And from then, the next item would probably be a full description of how your idea works. So you need to describe. Again, if the description is not adequate, they will tell you that you need to add more, you need to go deeper, it's not convincing enough. Then you would need to put up the right diagrams that illustrate the working of that concept. Then you need now to identify where your claim is exactly. And it's likely not to be the entire process, but maybe 1, 2, 3 components within that process. That would be an inventive step.
So I was wondering, did you have any challenges with any of your patents? First of all, how many of them have gone through? Because I know you've registered maybe at least 20.
Okay, yes, Carol, keep dreaming. The only 6, there have been 6 attempts. 5 have gone through. We have the certification, but 1 has particularly taken long. It's usually 18 months to 20 months that you'd have to wait between their first application and the final certification. But this has been now about 3 years.
So once you receive your patent, so you said you already have 5 which have been registered, and now you're able to commercialize them.
Yes, there would be, if you keep, there is a certain amount of money every year that you need to keep paying.
Okay.
I think it's still 3,000 or between 2,000 and 3,000 to service the patent for the 20 years that it takes it to be effective. Of course, any time after the 20 years, then it becomes public knowledge. Sorry, it becomes anyone's knowledge. Yeah.
So you've already registered your patents. You're currently being able to commercialize them because it was a unique idea. And if you, in case you wanted, you could also sell that patent to another organization.
Yeah. I need to mention, I think that is an important point. Okay, coming up with a patent, with an invention, of course, is not very easy. But the more difficult part is converting that patent into a knowledge that is exploitable within an industrial business process. Look at this. In 2023, if you go to statistics, there is the University of California that filed the most patents for that year, over 500 patents. It was the leading in the entire world. And yet Stanford University, which has a very high conversion rate, I think patented about 200, less than a half of what the University of California did. Yet Stanford made the most money, I think nearly 50 million USD for that year out of those patents plus the related knowledges or technologies. But because Stanford has the Silicon Valley that came out of Stanford. So Silicon Valley is next to Stanford and is made up of startups and extremely innovative industries that have what we'd call extremely talented scouts that would go through the entire list of patents and know how to convert these into industry, which then would make those millions of dollars. So that infrastructure is what is lacking largely in Africa and particularly Kenya. So there could be so many patents, but the ability to see through those patents and evaluate the gaps in industry that they could fill is difficult. And now it's upon you as the inventor to be the one to do that, look at industry and evaluate where your patent could fill gaps. And that's not so easy. Yeah.
Correct. And are there any challenges that might make a patent be rejected? Are there things that a young innovator should watch out for that could lead to your patenting process either being delayed or being rejected altogether?
Yes, that's certainly. A young inventor needs to first take courage. It's not an easy process, but it's worth it. It's worth taking it, because even if you don't benefit commercially, but I think the regret is bigger. If suddenly you see something that is come out, a new invention that is being used all over popularly, and you had thought about it 10 years back and you stayed silent, I think the regret would be more terrible than you never having benefited anything from it. So it's better to file, and you could also be lucky. But now what you need to do is look at the third point within those three conditions of novelty, of usability in industry. Look at the inventive step, because the inventive step insists that it must be an idea that an expert in that domain could not have thought of easily. So it cannot be an obvious idea. And therefore, you need to prove that inventive step. Then search endlessly. Because what I've found out over the years is what you think, what you conceive as a novel idea, 100 other people are likely to have conceived it in different, geographies or contexts. So you need to search and keep searching before you start finding.
But why don't you say something about that? Where can I search? If I have a patent, is there a website that I should go and search if this idea has been patented before? Or do I need to use lawyers?
You are best, you who is technical in that narrow area are best placed than any attorney to do that search. Because for people who are not non-technical, two very similar concepts that are really different, two concepts that are really different may look similar. So you're best searching. You can go to Google Patents. Google keeps an inventory of most patents that are coming out globally. Go to WIPO. WIPO also has an inventory of all these. WIPO, what is World Intellectual Property Organization. Then there's also United States Patent and Trademark Office also keeps a fair amount of, or keeps track of these patents. Now China is coming up with lots of patents annually. You may also want to check their sites. There must be some sites and evaluate. Yes.
Doc, there's you say that you
I know we want to open this up for the. Oh, sorry.
Oh, one last one.
Okay, all right, okay. Go ahead.
Okay, you mentioned that you have a patent that has taken over 3 years to be granted, an invention, sorry. I was just wondering, what are the challenges that you're facing with this invention? Is it because of the documentation, or is it that the office is taking so long to do the substantive examination? And how are you protecting this invention from being stolen before the patent is granted?
Okay, number one, I'm not protecting it in any way. It can easily go. The best way really to protect an application or a patent in process or a patent which has come out is to take it out to commerce or to use space. They use space to have it as a solution. That would usually be the best done, but it's not easy. We stayed there because they're taken so long to examine it, and I'm speculating that it could be some. The KP is a state organization, and it's clearly understaffed, and more so, it probably does not have enough. Patents can come from thousands of narrow discipline areas, okay? If you look at telecommunication alone, there could be probably 10, 20, 30 different narrow areas within telecommunication. And KIPI cannot have an expert in each narrow area. So chances are that they could be struggling. And of course, one thing I would personally suggest is if they could keep a network, a global network of reviewers that would be assisting them, just like with journals. Journals do that a lot. So that probably is the reason.
I think, Clarisse, we can now open it up because I see we have just about 20 minutes for this webinar, and I think we want to give an opportunity for the people who have joined us on this webinar to interact with a registered patent owner. So if you have a question, you can either type it on the chat box or raise your hand. And as you wait for your hands or your questions, maybe I can now ask my last question. So in terms of, you talked about commercialization, and for us in the Green and Digital Innovation Hub, we're trying innovators to be able to commercialize their innovations. And you said that's one of the ways in which you can protect the patent even before it's patented, to actually find usability for it. So if we, for us, when we're supporting the innovators, the green and digital innovators that are coming in through the hub or through the ACTS TISC institutes, would you advise them to, commercialize or start making money out of their, innovation before patenting, as the patenting process is ongoing? Or would that be a risk that that idea might be taken up? Karani Edward, we see your hand up, so you'll ask a question after this. Go ahead, Doc.
Okay. I have an opinion. It may be right or wrong. My belief is that the best way to protect your idea is to get it out into the conversion process, into a solution as fast as you can, probably even before you patent it. Get it out, because a working solution, it's difficult to diagnose. If I get a smartphone today, it may be difficult for me to find out exactly what the the small hundreds of pieces of technology which are in operation within that phone. So get it out as fast as you can, if you can. People will have varying abilities to get their inventions out into implementation. Some people would be very good at it. Some people like me would not be extremely good at it. But if you can, try to get it out as fast as you can.
All right, thank you. Karani, you can unmute yourself and ask your question.
Thank you, Moderator, for the opportunity. My name is Engineer Karani Edward. My background is in electrical engineering, and I think I've interacted with Dr. before, and he's done some awesome things in the industry. My question to him is on the challenges, and especially when it comes to the protection. Now, looking at it from idea to market, yeah. So you've a patent, you've already registered, but now moving that now to be able to service that patent, first of all, for you, the annual payments that you need to pay. At what point will you keep paying for the 15 years, or at some point when you see it's not making sense in the market or in the industry, then you're stopping? Because if let's say even if it's a family of patents related or not in a way, if it's like you now be incurring a fixed cost to just protect, whereas you've not yet gotten a route to commercialization. So how do you balance the two? That's one. Two is in terms of protection. If let's say you've done the registration, but now if you're protecting it just within, for example, the African context, or what is the cost? And if you go, for example, if you go through the axis, the Paris mini context, and you're protecting over a bigger jurisdiction, the cost implication vis-a-vis the commercial benefit. How do you analyze that and make a decision that these ones I will continue paying for these patents, these ones it's no longer makes sense to me for me, or whether it's now at an institutional level or at a business level? Yeah.
Okay. Okay, thank you, Engineer. I'll make an attempt. One is, okay, the two seem to be conjoined, and maybe I'll be able to address them luckily in one response. But the balance between keep service, the reason for servicing the patent for those 20 years that the law enables you to own them or to own it is in order to enable you to exploit it before someone comes in to take it away from you or to implement a similar idea. So the law accords you that privilege that you conceived it and you have all this opportunity to exploit it while you can. So the ability to exploit this, I think, should be fairly clear to you within the first 2, 3. For some, it will be clear right from the beginning whether they can exploit it. Some who are very strong would be able to go into the technicals and record and build the electronics and actually be able to build a prototype that they can show an investor or industry. For some, they would need to depend on other support infrastructure to do this. So within the first 4 years, I think it should be fairly clear to you whether you can or you can identify the right support system that can do this for you. I'll give you a quick example about one of my ideas was something on the television, the terrestrial broadcast television. So terrestrial broadcast television are these ones that are sold, these receivers that are sold to everyone over the air. The usual television as you know it, not internet-based, etc., but terrestrial, through the air waves. And they lack written channel. And you'd be imagining that if they could show what channel each receiver was tuned into at any time, and across millions and millions of such receivers, that would be, a gold mine to organizations that do, consumer research. So, but it's difficult to implement this idea as an individual. I would need to work with a television manufacturing company, to exactly affect this, have a prototype which is out, so I'm evaluating, and your question is actually playing in my mind every day. At what point then I need to just let it go, and at what point that I think I would be able to find the right people to support system for this. So it's a difficult question, engineer, and even going across jurisdictions. For instance, my patents are within the country, but if I wanted to go continental or global, I would have to pay more, but I would still have to consider, evaluate very carefully whether it's a good investment, paying that sort of fee.
All right, thank you. I think engineer's question has been answered. So Linus, please unmute and ask your question.
Okay, thank you, Doc, and thank you, Dr. Ojenge, for the presentation. I think my question has been asked in part by engineer. My question was on territoriality. Just wanted to know if maybe you've patented your idea in Kenya. Can someone, let's say from Uganda, just when they come across your idea, then they can just proceed with it and implement it in Uganda? But I think Doc has addressed that in part that, yeah, you can protect it. Maybe now you can widen the scope, the geographical scope of your protection. That was my question. Another question that I had also has been answered about the patent protection duration, but I've had engineer mention 15 years, but Doc actually mentioned 20 years, but there's I understand that there is some annual fee paid, maybe annually. But now another question: if you default paying this annual renewal, this annual fee, does your patent now go public, or it's revoked or something? Thank you.
Thank you, Linus. I think the last one is whether if you stop paying, if you default, then TP would just not protect you. I don't think they will publicize your idea. But if anyone want to use your idea within those 20 years within the country, then they would not protect you. I'm not very good at that level of law, but that's what I think.
And so now that your ideas are protected, is there, we know about music, for example, when somebody has music and somebody samples, we know that there's certain payment to the originator, the writer, or the composer. But in terms of a patent, what is the percentage? If you found out somebody had used your idea, to advance something else that they were doing, what is the payment structure, for example, or the penalty?
Okay, again, I'm not very fluent in that space, but I know this. It would be a negotiation. If they were to use that idea, particularly the component that you protected, then they would want to come negotiate with you and offer some compensation, and you would, I think you'd need to negotiate and agree. Yeah. But of course, it's also possible that they could exploit that concept without you knowing. It could be hidden within a larger technology, and you wouldn't know. Yes.
Yes. And also, you might not be commercializing your invention yet, but they could take it and commercialize. And so you might not be able to encounter that until you go back to the patent office.
Yeah. Yes.
There's, I think Harrison Otieno talked about the costs involved. I think he says his connection broke off on that part. And I think I would suggest that we even just do just a breakdown. Maybe Clarisse and I will work on that to do costs on how much patents are involved, and then share it with the people who have attended this webinar. I think that would be ideal. Or do you want to speak something about the cost again? But I think since it's a table on the kind of cost involved, especially the annual cost, I think it would be good that even we can send a small template, giving the breakdown of costs, and especially now that we are technology transfer center, that can be something that we can do for the innovators who have joined us. Clarisse, do you have closing questions? I think we'll take the final questions to Dr. Ojenge. If you have another question, please raise your hand. We'll be taking the final 2 questions. Clarisse, go ahead.
I don't think I have any further questions. He has done a good job and given us insights on the patent registration process. So unless the participants have something to ask, maybe they could just raise their hands.
I think there's a question on bureaucracy. The bureaucracy involved. Yes, go ahead, Samuel. Ask the question.
Samuel, you could unmute yourself.
Samuel?
Thank you. Thank you, Doc. Can you hear me?
Okay.
Yeah.
Can hear you.
I think Dr. Ojenge has given us a quite insightful presentation on the process of patenting and even some of the some of the things that are required when you want to patent. But then we understand the process of patenting is quite difficult when it comes to the bureaucracies that are sometimes involved. So maybe he can give us some of the examples of the challenges and even the bureaucracy that he encountered sometimes before, because he has done quite a number of patenting. Because it is an issue that we hear even from other countries when you want to patent something and it is involving commercialization, and maybe it will affect the other people in terms of leveraging on those technologies and even their commercialization again. So maybe you can give us maybe an overview or the experience of what he has heard before. Thank you.
Okay, thank you very much, Samuel. So there is, I think they're pretty standard. Whether it's, the difficulty in evaluating whether what your idea is patentable, whether it's adequate intellectual property to patent is, it's difficult, especially among the youth who are most innovative. It's also a lengthy process, 18 more years, more months, but you could want to start, converting it if you can into some prototype that then you can show investors or potential users in industry. The cost is also fairly high for youth at 14,000, about 120 USD. A lot of youth may not be able to afford, but you can still work with university patenting offices. There are also hubs. I think GDIH as a hub, Caroline would confirm, could support you, likely for some equity. And developing the patent application is also challenging, but all this is worth it. Don't sit with your idea, get it out as fast as you can, and also interact with the KIPI website. All these fees are there. Interact, you'll be surprised at the mountain of information that is there that you never knew. Thank you.
Hello.
Go ahead, Philip.
Thank you, Madam. I just wanted to reiterate the fact that Daktari has shed more light on the process, because we have been doing it blindly. We have been patenting year in, year out, maybe during the debate fairs, and some pertinent issues which have been touched by Daktari has become so clear to me. And now that I can go for full patenting, because I've received notifications to complete a patent, to get a full patent. So I want to say the information is very enriching, and we look forward to having more on this, so that the ideas of our students will also be fully patented. Thank you very much for this convention, and I look forward to joining you in future, even for further training as such. I'm Langat from Olesos Technical, Olesos National Polytechnic.
Yes, I was actually wanted to ask you to introduce yourself, because you talked about Tibet, but we've gotten where you're from.
Oh, yes. This
all right, and
Olesos National Polytechnic. Olesos National Polytechnic.
Congratulations.
Thank you.
Okay, congratulations on the patents which are currently in process. And we'd be more than happy to hear more from your team as well.
Thank you so much.
All right. Okay. All right. Thank you. Thank you. Dr. Ojenge, you want to say something to Mr. Lagat?
Yes, I would urge him to work extra hard get the IP of its students into examination. It's really great for his students and
Yes.
and for the country to have as much of these concepts in one inventory that then becomes a gold mine to industry.
Yes. Thank you, sir.
All right.
We'll do so.
And
Thank you so much.
yeah. Thank you so much. I think I see we have run out of time. I just want to give a vote of thanks to our speaker, Dr. Ojenge. Thank you so much for the insights. And thank you so much for interacting with us and also with the innovators. As you can see, there's a lot of people who are interested in this, and also not just for themselves, but as Philip said, he's also interested in supporting innovators at TVET level. And this is a very good avenue for people to understand how best to carry out the patenting process, at what point the idea is ready for patenting, and how you can engage a lawyer, or how you can tap into the resources of a digital innovation hub. So thank you so much for your time. And for everybody who joined us, we are very grateful, and we look forward to having you join us in other webinars, that we are going to be holding on the IP process. All right. All right, thank you so much, Dr. Ojenge. We are very grateful for your knowledge, for your insights, and we look forward to having you on board again. All right, goodbye, everybody. Thank you. Thank you for joining us.
Bye. Bye.
Bye.
Bye.
Thank you, Doc. Thank you, everyone. Goodbye.
All right.
Bye.
Bye.
Goodbye.